Good evening. Thank you for tuning into Mojo Story. I am Muskan Nagpal, and today we are going to discuss the raid on Advocate Mehmood Pracha's office that took place on December 24. On December 24, the Special Cell of Delhi Police raided Advocate Mehmood Pracha's office in Nizamuddin West. In the most recent development, Delhi Police has booked Pracha for obstructing an officer on duty and abusing an officer. Pracha is representing around 150 cases of those who've been victim of the Delhi riots, including Gulfisha Fatima, who's been booked under the UAPA. The raid at Pracha's office started at 12:40 p.m. on December 24 and continued till the next morning at around 4 a.m. on December 25. Delhi police has said that Pracha has been accused of forgery and criminal conspiracy. According to a senior police officer, Pracha filed an affidavit in the court that was allegedly notarized by a lawyer who had died in 2017. The police claimed that since it was notarized by a lawyer who died 2.5 years ago, it was a false affidavit and the signatures were forged. The police has also alleged that Pracha had asked a man named Irshad Ali to falsely identify people in a case related to the Northeast Delhi riots. When these concerns were raised in the Karkarduma court, the court had said that the Delhi police should conduct an investigation looking into the matter and pass appropriate orders. Mehmood Pracha, however, had denied all of these allegations and said that he's being threatened because he's representing those who've been accused of involvement in the Delhi riots. As of now, Pracha's laptop has been seized, and he has called the seizing of his computer unconstitutional because it violates attorney-client privilege under Section 126 of the Indian Evidence Act 1872. Many have said that this incident also violates the fundamental right to legal representation. To discuss the matter in further depth, we have with us today Vidushi, who is a lawyer from Mehmood Pracha's chamber, and Raghav Awasthi, who is also a lawyer. So my first question is that to Vidushi, why do you think that the raid by the Delhi police is a violation of the fundamental right to legal representation?
Sorry, I couldn't hear you. Can you please repeat your question?
Yeah, my question was that why do you think that the raid on Mehmood Pracha's office is a violation of the fundamental right to legal representation?
I'm sorry, your voice is not clear to me. I just can't hear anything.
Oh, all right. Let me just try this again. While we test this out, could we please have a video of the raid at Mehmood Pracha's office that has been taking the rounds on social media right now?
No, there's some problem.
ऑप्शन की बात ही नहीं है ना, ऑप्शन की बात नहीं है। आप यही तो ऑर्डर जज साहब से लेके आए हो, अब आप भी बात हो। देखो मेरे साथ जो कंप्यूटर देख रहे हो आप,
ठीक है सर, फिर हम कर लेते हैं सारे कंप्यूटर को।
आप सीज नहीं कर सकते, वो कंप्यूटर नहीं बना है, आप देख सकते हो।
नहीं सर, मैं तो फिर मैं सीजर का वो है ऑर्डर पढ़ो आप, चलो सीजर मैं ये इनकी हार्ड डिस्क ले लेता हूँ, और अगर मान ली हार्ड डिस्क नहीं निकलती तो सीज कर लेता हूँ सर।
सब सीज कर लो, ये भी आप कर लो, लेकिन ये ऑर्डर के खिलाफ है
सर।
इसको मैं आपको नंबर निवेदन कर रहा हूं, आप अपना ऑर्डर पढ़ के सुनाओ
सर। मैं तो आपको कह रहा हूँ कि हम करना ही नहीं, हम करना नहीं चाहते।
मैं कह रहा हूँ मुझे उठा के ले चलो, लेकिन क्लाइंट अटॉर्नी रिलेशन में नहीं चलता,
हमें तो मजबूरी में करना पड़ रहा है।
अपना वारंट पढ़ लो, उसके बाद जो नहीं सकता
वारंट मैंने तो आपको दिया
नहीं, जज साहब ने लिखा ना ऑर्डर तो जज साहब ने दिया होगा ना, ऑर्डर है आपके पास, मैं ऑर्डर को जज साहब को पढ़ के सुनाता हूँ।
हाँ मैंने
दिखाओ, ऑर्डर दिखाओ
जज साहब का ये वारंट आप।
Right. So that was the video where we can see Mehmood Pracha saying that he will not violate attorney-client privilege. Vidushi, can you hear me now? Hi. Am I audible to you now? All right. It seems like we cannot reach Vidushi at this point in time. So I'm just going to move on to Raghav. Raghav, could you please tell us that does the seizing of computers violate attorney-client privilege?
Yeah, so I think it's really important you mentioned a provision, section 126 of the Indian Evidence Act. So 126 of the Indian Evidence Act is very clear. It says that communication that is made in furtherance of an illegal purpose is not something that is inadmissible in evidence. So essentially, if, for example, let us say there is a client who comes to me and says that he has committed a murder, and then he wants to defend me, then this confession or communication that he makes to me is not admissible, right? So as far as that is concerned, we should be very clear. However, if that client comes to me and says that he wants my advice as to how he should murder somebody so that he's not caught by the police, that conversation is not privileged. So if there is something in the emails or that Mr. Pracha has exchanged with his clients, wherein he's advising them to file a false affidavit, or wherein he's advising them to forge some documents or whatever that might be, if it is in furtherance of an illegal purpose, then the police are well within their rights not only to raid Mr. Pracha's office, but also to use those documents against him and his client in court. Any other interpret, because just because you're a lawyer, it doesn't mean that you're above the law. If you're defending somebody, even if you know that that person is guilty, then that defense is not an illegal purpose per se. But when you are sitting with your lawyer and trying to forge some documents or filing some false complaints, then that is definitely not something that is something that you're allowed to do just because there is attorney-client privilege. I would really appreciate if you could just put section 126 of the Evidence Act up on your screen, because if viewers read the illustrations as well as what the provision says, everything would be clear as day. Under the Indian Evidence Act of 1872, I would repeat, if the lawyer and the client are conspiring to do something illegal, then that is something that is not protected. That is not protected under the Indian Evidence Act. So there is no confidentiality in that respect. Let me complete. Even let us assume for a moment that they find 10 communiques, right? And 3 communiques are privileged, 7 communiques are not privileged. Then the communiques that are privileged, they will not be able to use in court. But the rest of the 7 communiques, which are not privileged, can definitely be used. Section 126 does not also provide a blanket protection to all officers of the law to the effect that their office will never be raided irrespective of how strong there might be a suspicion that they are conspiring with their clients. Because this is like, giving lawyers an immunity from the operation of the law. This is not how Section 126 is supposed to work. Please put it up out there. Thank you.
Right. So my question to that is, but does the police need to seize a computer for that, or is it possible for them to skim through the emails and figure that out? Because as of now, it's not clear that the accusations against Pracha, they've not been verified as of now, right?
So when it comes to seizure, it actually depends a lot upon what the magistrate's order is. If a seizure has been ordered, then those computers have to be seized. And in any case, if there is some communication that comes under the ambit of attorney-client confidentiality or attorney-client privilege, then that communication even if the police chances upon something like that, it cannot be used in court. Let us assume for a moment that there is an email in which a Delhi riots accused has said to Mr. Pracha that, look, I have killed such and such person, and now I want you to defend me. So that portion the police cannot use in court in any case. So that portion is inadmissible in evidence. So I don't know what the halabaloo is about. If there is something that directly goes against the interests of Mr. Pracha's client, when it comes to a crime that he's committed before he started being represented by Mr. Pracha, that communication is in any case not something that the police can use even if they seize all of his computers. But the fact that Mr. Pracha is obstructing the police when it comes to performing their duties means that Mr. Pracha has something to hide, means that he's also hand in glove with the people that he's representing. Look, a lawyer cannot be penalized for taking up unpopular causes. And I don't think lawyers should also be censured by the public if they take up the case of somebody whom the public thinks is guilty, because that's a lawyer's duty. But a lawyer's duty does not extend to conspiring with his client and fabricating evidence. You can do that. You can represent your client to the best of your capacity without getting involved in a crime yourself, is the limited point that I'm trying to make. And this is also the import of Section 126 of the Indian Evidence Act.
Right. So since I'm not an expert on this, I'm going to need Vidushi to respond to that. And if you could please, Vidushi, am I audible to you now?
Now you are, yes.
Right, okay. So it's really sorry about the confusion. I'm just going to ask you once again. Yeah, cameras falling off again, surfaces is something that all of us as a generation deal with right now. So so my question is that why do you think that the Delhi police, the act of the Delhi police raiding the office was a violation of the fundamental right to legal representation?
Yes, so I would want to go a little in the background of the matter as well. Ever since Mr. Pracha has taken up the Delhi riots case, and prior to that too, a lot of time there has been direct or indirect threat to him and to the clients to not engage him, threat to him not to take the matters. And if we go in that series of events only, so this raid was also a part of it. Now, as a lawyer, when a client comes to you, then there's an unsaid client lawyer confidentiality, whereby the client expects you not to, whatever he's sharing the information with you, he expects that data to be safe with you. So this raid conducted by Delhi police, the order was very limited for them to check a particular email, a particular mail that had been sent to the commissioner. So they could have actually checked the mail from account of Delhi police commissioner, but they chose to come here as an act of intimidation. And
I think we just lost Vidushi there.
am I audible?
Yeah, now you are.
Am I audible?
Yes, you are now.
Hello?
Yeah, Vidushi, am I audible to you? You are audible to us.
Am I audible to you?
Yes, yes, you are.
Okay. So the warrant specifically said that they were to look for documents that were a false complaint and metadata of outbox of email account. That was the limited order that was passed. And when they came to the office, Mr. Pracha, obviously, due to the client-attorney relation, could not tell them, give them any data related to the client. He opened his email account. They could have just looked for this mail, checked it, which they did also within 5 minutes, and they could leave. But they decided to harass him further. They decided to stay here for another couple of hours just to intimidate him.
Right. So my next question is that Raghav here just said that if the information that is in those emails is something that is illegal, then the police is allowed to seize whatever is necessary. So, and he also said that if the order states that the police cannot seize the computer, or if it says has a range where the police is allowed to seize items, then that is illegal. So, Raghav, would you like to respond to that?
Yeah, I think what Vidushi has said betrays an utter lack of understanding of what attorney-client privilege is. I don't know, I don't know where she graduated from or how long she has been practicing, but the Indian Evidence Act doesn't have any sort of blanket attorney-client confidentiality. Attorney-client confidentiality only extends to material that is germane to your defense of your client. So if it is not in relation to the defense of your client, and if it is more about, fabrication of false evidence and affidavits, then that's not protected by attorney-client privilege. And I think one more thing that needs to be understood, that attorney-client privilege also does not apply the way it does on American shows like The Good Wife. So we are not on American legal, not in an American legal drama at the moment. As far as the Evidence Act is concerned, even if the police, as I said, chance upon something that is covered by attorney-client privilege, then then they won't be able to use that in court. It's as simple as that. How difficult is that to understand? But as I said, Mr. Pracha has something very serious to hide, because even though, and I know Mr. Pracha very well, he's somebody I've interacted with in the past. So he knows very well that if it is material that can actually be prejudicial to a case of his client or whom he is representing in court, then that material in any case is not admissible. How is it admissible? If it's not admissible under the Evidence Act, and if there is other material that can that is in relation to conspiracy, then that material will of course be admissible under the Indian Evidence Act. So I think Mr. Pracha is just trying to be too clever by half, and he's trying to garner some sort of sympathy for himself as far as the legal fraternity is concerned. But the legal fraternity should also not stand up for members who are accused of wrongdoing, who are doing wrong things that the Advocates Act or the Indian Evidence Act does not allow them to do.
Right. Yes, Vidushi, you might want to
I
respond to
would
that.
first like to clarify something that the. Am I audible?
Yes.
I just want to clarify that Mr. Pracha has nothing to do with that affidavit. What my dear friend um, has just claimed that he's related to the case relating to the affidavit. It is just about a complaint that his client had come and had told him to file on his behalf. And as a lawyer, lot of time clients come, they are not well versed with the legal language, and lot of lawyers help their clients in drafting of their complaint. So he has nothing to do with that affidavit. And judiciary is the third pillar of the democracy. And if my dear friend, who himself is a lawyer today, says that there is attorney and client confidentiality is not part of the Evidence Act, but I'm sure you must
No,
have
I
read it
didn't
in
say
your
that.
PhD paper
I'm really
that
sorry. I
there
didn't say
is,
that. I read law at
let's say, there's
Nalsar.
a
I don't know
concept
what
of.
law college you went to. I'm sorry.
All right. Let's
I
not.
didn't say that.
Let's
Thank you
let us
very much.
not.
I
Don't
was in Delhi
misrepresent what I'm
University and
saying.
we're not here to discuss our
I
law
was
politics. Excuse me.
I am going. I
Just
have.
stick to the topic. I don't really
Let's
like
stick to the
indulging
topic.
in
You're the one
any
who's
personal attacks in
beating
political
around the bush.
debate.
Okay, I don't think we need to talk over each other because that goes nowhere. And I don't think we either need to make personal remarks. So we're talking about where someone went to college and where they did not. Let us just stick to the topic at hand and discuss the legality of the matter. Vidushi, I'm going to come back to you and you can complete your point. And Raghav, I'm going to give you time to respond to that. Let her first complete her point, please. Yeah, Vidushi, you can go ahead.
Can I continue?
Yes.
Yes, so that's what I was saying, that while it might not be covered under any act, but client and attorney confidentiality is a very basis of our profession. And if anybody will ask me to give any information about my client, be it any officer or anybody, I will not give it, because that's what our profession is based on. Our clients come to us, they rely on us, they believe in us, that whatever they are telling us is not going to be shared. Their data is safe with us.
Right.
Can I now come in? Yeah, thank you.
Yes.
Can I respond?
Yeah.
Yeah, so I would, it's really good that
Yeah.
my learned friend has admitted that this special attorney-client privilege that she's talking about. I never said that there is no attorney-client privilege. That this special attorney-client privilege that she's talking about, which extends to all communications that any of her clients might have had with her, does not exist under any statute. She is right. Under Section 126 of the Evidence Act, if there is a communication that your client has had with you in relation to an illegal purpose, the same is not protected. I'll say it again and again, and it's there in one of the illustrations to the Indian Evidence Act, in the to Section 126 of the Indian Evidence Act. So, as I said earlier, if your client comes and tells you about a crime that he has committed earlier, and then he says that he wants you to represent him, and then you advise him, that is fine. Those communications are privileged and protected. And even if the police chances upon those communications, they cannot be used in court. So that's one thing. However, if the client comes to you and you advise your client to file a false complaint, and then you say that you don't want to give up the communication that you've had with your client because they're protected by attorney-client privilege, which admittedly, even according to Vidushi, the sort of attorney-client privilege that she's talking about does not exist under any law, then the law is not going to spare you. And such unscrupulous lawyers who conspire with their clients and fabricate false evidence bring great disrepute to our profession, and they bring great disrepute to people like us who try to practice a profession in the most scrupulously honest manner.
Okay.
I'm thankful to you for explaining that what attorney-client privilege is under, and
Yeah,
what
you
you
needed that explanation,
said right
Vidushi.
now makes
You are
exactly
clearly not
what the
very.
police wanted from Mr. Pracha. The police wanted him to tell. Am I audible?
Yes, yes, you are.
Am I audible?
Yes, Vidushi, you're audible. We can hear you. Can you hear us?
So whatever the clients come and tell us here, we can't share it. Whatever the police wants to, whatever story they want to give, and whatever my learned friends wants to believe, he can. But whatever our clients come and tell us here, we are not going to ever give that information to anyone. And because of this raid, this illegal act of the police, our other clients have also been suffering, and they will take action about that as well, because even their data has been accessed by the police.
Right. Okay. I saw that Raghav wanted to respond to that.
So Vidushi just said that even though her brand or her version of attorney-client privilege is not there under any law, even then, if the police comes to them and says that we want information in relation to some of the communication that Mr. Pracha's client might have had with Mr. Pracha, she said that even then she's not going to disclose that information. Then, in that case, I'm really sorry. I don't know how long she has been practicing, but such practices are not protected by the law. And if she is indeed, I'm giving her the benefit of the doubt. So if her boss is conspiring with with some of his clients to fabricate something or forge something, or if he is getting an affidavit notarized by somebody who's already dead, then there will be consequences. Because no matter how high you are, the law is definitely going to catch up with you. And the law has कानून के हाथ बहुत लंबे होते हैं. And even though you might be exalted, the law is the same for everybody. And there is a very, very narrow set of cases wherein attorney-client confidentiality applies in this country. This is not America, and I would really urge Vidushi and her boss to stop watching so many police procedurals or legal dramas from the United States, because yeah, I mean, they should have gotten the memo by now, but this is not America. This is India. Thank you.
Right. I'm just going to let
Wish
Vidushi,
I
you were
was
on mute.
that were
You
like
you
you
can
who
you'll
sit and
have
watch
to.
dramas. I would, if you permit, I will just read a part from the warrant, which specifically said about a false complaint and metadata of outbox of email account. No affidavit has been mentioned here because Mr. Pracha's case is not related to any affidavit. My learned friend should have gotten his facts correct before coming here and speaking like this about a senior who has been fighting for the rights of underprivileged. And I'm really sorry that you didn't even know your facts and you just came here and you are building some
Really
false
sorry that
stories.
you didn't even read the Evidence Act in college. I'm really sorry about that. You should read the Indian
Oh, I
Evidence
was
Act,
not
Section
in your college.
126.
I'm sorry. Yeah, I could
Yeah,
not.
that's why
Even
you
I
could
was
not
there.
crack
I
the
couldn't
entrance test.
come
That's why
for
you
the
were not in
lecture.
my college. That's the
I
reason.
don't
Yeah, that's
I
the
don't
reason why you
think
couldn't
we
get
need
into my
to.
college. Do you still
So
feel bad
let's
about
stick to the
that?
topic. Let's stick to the.
I'm just going to put both of you on mute. I'm just going to remind you again that let us not attack each other personally regarding where we've studied, what we should have read, what we shouldn't have read. Right now, we can clearly see that none of you is agreeing on the facts of the case. So I'm just going to move on to the next question. And my next question is that many of people have said that with Mehmood Pracha's office being raided as a part of an ongoing investigation by the Delhi police. And but if it, like many have also said that it is a violation of a fundamental right to legal representation. So if it's an ongoing investigation, and it is also violating a fundamental right, how is it that one can negotiate through such a tricky terrain? Dushi, would you like to come in here?
Yes. So I would again want to read the warrant that was issued by the court, which clearly mentioned that the police were to search for incriminating documents comprising a false complaint and metadata of outbooks of email account of our official ID. That so one has to stick to whatever their jurisdiction is. The police could have come here, checked whatever they were supposed to, and could have left, and their investigation would not have been hampered. And then they were to immediately file whatever they recovered from here in the court. But the police chose to harass everyone present here. They did not let our associates enter the office. They and email, you check from any computer, emails are like same. You don't have different emails from different computers. So once Mr. Pracha allowed them to check his official ID from his computer, they decided to check all other computers in the office. They decided to seize his laptop. So this act was illegal. As far as the jurisdiction of the order was concerned, Mr. Pracha was ready to help them out, but beyond that, the harassment he did not stand for, and no lawyer should ever stand for that harassment by the police.
Right. So, Raghav, if she is arguing that the scope of the jurisdiction just asked them to look for incriminating documents and that meta set of emails out of outbox, how would you respond to that? If there's a limit.
And so I want to explain to the viewers two things. First is that now she seems to be changing the goalpost. Now that she knows that she's not protected by attorney-client privilege, she's saying that the raid per se exceeded the contours that were laid down by the order. So I'm really glad that she's admitted that attorney-client privilege comes nowhere into the picture, because her communications with her clients are not covered by attorney. All of the communications are not covered by attorney-client privilege, and the communications that are not covered can indeed be accessed by the police. That's one thing. Now, as far as whether or not the police exceeded its jurisdiction is a whole other question. I thought this was about whether the fundamental right to legal representation was hampered by the mere factum of the raid. I mean, there is, of course, a possibility that the police exceeded whatever the court order allowed them to do. So, in that case, the correct remedy is to approach the court. The correct remedy is not to, grandstand and say that the right to legal representation has been hampered, because the right to legal representation, as I said earlier, does not extend to conspiring with your client and filing false complaints. It does not extend to that. Your right to legal representation extends to providing to representing your client with respect to a crime that he might have already been committed. Even if the client is guilty, it's your duty as a lawyer to represent the client to the best of your capacity. But it's not part and parcel of your duty to assist your client in committing further illegal acts. That's not something that a lawyer is supposed to do. And the worst part is that after doing all of this, and against them there is prima facie evidence, these people are now, crying from the rooftop and saying and trying to project as if their great fundamental rights have been violated. So that's not the case. And as far as the right to legal representation also is concerned, the contours of the right cannot be determined by Vidushi, Bajpai, or Mehmood Pracha. They should show us some judgments that say that just because somebody is a lawyer, then their office cannot be raided and all of their communications with their clients are protected. Why doesn't she show us some judgments? I quoted section 126 of the Indian Evidence Act in full. I even quoted the illustration. She should also quote some judgments now and say whether the Supreme Court has said in any case that if a client has any communication with their lawyer, then the communication cannot be accessed, or they cannot be or they cannot be accessed by the police.
Right. Vidushi, you were saying something?
Yes. So, firstly, I would just want to say that both the aspects, I stick to my point. I don't know how and why my learned friend is just manipulating whatever I'm saying. I still stick to the point that client attorney privilege is very well protected under law. It is taught to us when we learn ethics and advocacy paper. And so this entire case has to be looked into by, like, there are two separate issues we are dealing with. First, client attorney privilege is available to us, and as lawyers we are not supposed to share that information with anyone. Second, this raid was illegal. It was beyond the jurisdiction, beyond the scope of the order passed by the court. And not only has this raid been conducted illegally, all other data of our clients has been compromised with. The police has taken every data there in the laptop. They have seized Mr. Pracha's laptop, and now they have compromised with data of all other clients. So now the attorney-client privilege is definitely an attack on legal profession.
Right. Okay.
Can I come in here? Can I come in? So she just said that there is attorney-client privilege. I totally agree with that. But then she went on to define attorney-client privilege in such expansive terms. And then she talked about something that she might have read in a legal ethics paper. I would like to remind her that the Dukki that she read to, I'm sure, ace a legal ethics paper, that is not authority for what attorney-client privilege in this country
Firstly, you
is.
don't do
I
personal attacks.
quoted
I can do that
I
very well,
quoted
Mr.
to her
Raghav, but
section
I'm
126 of the
not here
Evidence
to
Act.
do any
Why don't you
personal
cite some
attacks.
authorities?
You please
Why don't you cite
not.
some authorities? Why don't you cite some authorities? Authority is either statutory law or it is a judgment that has been laid down by a competent court of record like the Delhi High Court or the Supreme Court. Why don't you cite an authority? Please cite an authority. Without citing any authority, I'm pretty sure that this is not the way to succeed in an actual courtroom where you don't cite an authority and say that okay, attorney-client privilege is there. An attorney-client privilege is exactly on the same lines as I define it to be. You're not an authority as yet, neither am I. Both of us have to go by what the High Court has laid down or what the
Right.
legislature has laid down, or for that matter, something that the Supreme Court has laid down. That is also authority. Finito.
Raghav, all your points are well taken, but I please request you to not get personal and not bring in things repeatedly. Vidushi, you wanted to respond to that.
I have already laid down my arguments, and I will stick to them. That Section 126 of Evidence Act covers attorney-client relationship and confidentiality. And second part of it is this raid on Mr. Pracha's office was illegal raid beyond the scope of jurisdiction of this order, and this raid was only done to threaten him and to threaten his clients indirectly, so that his profession suffers.
Okay.
And I would want to
Considering that none of us is going to move on from this, we'll just have to change the question at hand then. So I just also want to bring in talk a little bit about how this case has largely also thrown light on how the Delhi police has dealt with cases involving the Delhi riots. So it is also true that Pracha was earlier accused of inciting violence when he said that minorities should go ahead and buy gun licenses to protect themselves from lynching. But all right, he has been a controversial figure in the past. But so have been many other, like say a Kapil Mishra, who will go ahead and say that. Like Kapil Mishra went ahead and said that at Jafrabad, that if people do not clear up the roads, then their men will have to come in and have to get it khali. And so did Anurag Thakur, who is, by the way, a member of the parliament, who said that Desh ke gaddaro ko goli maro salo ko, and even Pravesh Verma, who is another MP, who said that if he be elected to the Delhi, if he wins the Delhi, if BJP wins the Delhi elections, then he will demolish all the mosques in his constituency. But no FIRs have yet been registered against Kapil Mishra. And in fact, we have information that Mehmood Pracha has also been involved with people who filed complaints against Kapil, who have filed a petition against against an FIR being registered against Kapil Mishra, and complaints against DCP Northeast Delhi, who's Ved Prakash Surya. So do you think that this is the kind of, it says something about the way that the Delhi police has handled the Delhi riots? Vidushi?
That's what I have been trying to say. In the very beginning, I said that this matter is not a standalone matter. We have to see it in the chain of events that ever since Delhi riots happened, and since then, this entire conspiracy has been going on. How to pin everything, how to, silence the voice of underprivileged, how to silence the voice of victims. And so this entire conspiracy has now reached to this point where the police is just trying to intimidate Mr. Pracha by doing such illegal acts. That's what I just said in the beginning, that we have to see this entire case in light of everything that has been happening.
Right. Raghav, you wanted to respond to that?
Respond to it. And I'm really glad that Vidushi ji finally even mentioned that there is a section 126 of the Indian Evidence Act. And yes, she should also read it. But coming back to the larger point of what she said, that there is some sort of a great conspiracy, I think the people of Delhi know who the conspirators are. The people of Delhi have seen how Ankit Sharma's body had to be fished out of the water. as if he was some sort of a dead animal. Everybody knows what Tahir Hussain was up to, how Hindus were killed just because, they did not follow the same religion that Tahir Hussain and Mehmood Parcha follow. So everybody knows what happened, and the people of India have full faith that Narendra Modi ji and Amit Shah will protect them from some these incidents in the future. And this is the mandate that Narendra Modi and Amit Shah have, and they will fulfill this mandate. And I will say it again: the days when there was a Muslim veto when it comes to things that are happening in this country are over. There is no such veto now. You
Right,
cannot
Raghav, I
kill Hindus
understand
with
that. I
impunity like you
understand.
killed in 1990 and get away with it again. Thank you very much.
Okay, right. I understand that there were Hindus who were killed, but there is also enough evidence suggests that Muslims were killed. There have been reports about it. There have been reports representing both the sides. So we cannot simply overlook that. So, but considering that we're having a discussion where we're not able to move on from this point, I think it's best for us to go ahead and research more and read more and figure out where we should stand on certain issues. And so I would like to end this discussion right now on the note that Mehmood Pracha's office was raided and he has now been booked by the Delhi police for abusing an officer and obstructing an officer from doing his duty. His member from his team, Vidushi, said that the raid is illegal because it went beyond the scope of the jurisdiction, and we could not have an agreement about whether attorney-client privilege is sacred in our country or not. So thank you to our panelists for joining this discussion, and thank you to our viewers for tuning in.